Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with a vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Thank you for joining us today for our online talk entitled Goods Sold and Delivered. My name is Rachel Ng. I'm a pupil in Chambers with Ma Wing Kwai and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by our Datuk Ma Wing Kwai. Our able team today comprises of 23 lawyers and a support team of 19. Today, Datuk Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, as well as a department focused on servicing the needs of individuals. And our practice groups, as you can see from the slide, indicates some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. With the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is our third talk in year 2021 for our online talk series, which has been attended by some 3,000 attendees. Today, we are expecting 156 people who have registered. Please visit our website at mahwingkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for complimentary legal consultation, details of which will be given at the end of this talk. We have two speakers for today, Ms. Hannah Patrick and Mr. Heng. We will conclude today's session by addressing questions raised on Slido. Allow me to introduce our speakers for today. Our first speaker today is Ms. Hannah Patrick. Ms. Hannah is a senior associate in our firm, and she practices in the areas of general litigation, construction law. Hannah graduated from the University of Malaya with a Bachelor of Laws in 2012 and was admitted to the High Court of Malaya in 2013 and then to the High Court of Sabah and Sarawak in 2017. Our second speaker for today is Mr. Heng, who is an associate in our dispute resolution and individuals and families departments. Mr. Chiu obtained his Bachelor of Laws with honours from the University of London and was admitted to the Malaysian Bar in year 2020. His areas of practice include general litigation, family, citizenship, adoption, probate and administration of estates, debt recovery, and land disputes. Our speakers will target to complete their presentation by 3:30 p.m. and then they will address the questions posted on Slido. If you have any questions, please post them up on Slido. You can access the Slido page by scanning the QR code, which is shown on the slide here, or going to the Slido website and key in the number 17071. I repeat, the number 17071. Today's talk points are as follows. Point 1, the overview of the law on the sale of goods. Point 2, defective goods. Point 3, delayed or non-delivery of goods. Point 4, non-payment for goods delivered. And the final point, remedies for both buyers and sellers. Chiu will be covering point 1 and 2, and Hannah will take over to discuss the last 3 points. We will now invite Chiu to start the talk. Over to you, Chiu.
Thank you, Rachel. Good afternoon, everyone. I will be speaking first today. So as we all know, the COVID pandemic and the MCOs that have been implemented since last year has had a very huge impact on the manufacturing and the sale of goods. There has been a discrepancy between supply and demand. Initially, last year, many manufacturers were not able to operate and there was a shortage of goods. However, statistics have indicated that since the start of the pandemic in the MCO, there has been a huge increase in online sales and e-commerce. Based on the statistics, e-commerce participation among SMEs have increased by 3% between March and October last year, and there's been about 373,000 entities that have registered with the Companies Commission under the online category. So we will now move on with the overview of the sales of goods in Malaysia.
Chiu, I will share the slides and you can just speak from there. Is that okay?
Okay, sure, thank you.
Okay.
We will first start with the overview of the law on the sale of goods. Hi Hannah, are you sharing the slides here?
Hang on. Sorry everybody. There seems to be a little bit of an issue with our screen. Okay.
Sorry for a technical glitch. Okay, we will now start with the overview of the law. The following legislations shown here govern the sale of goods in Malaysia. We have the Contracts Act, the Sales of Goods Act, and the Consumer Protection Act 1999. For the purposes of the talk, we will be emphasizing on the Sale of Goods Act, or known as SOGA. Under Section 2 of the SOGA, a buyer is a person or a corporate entity who buys or agrees to buy goods, and a seller is a person or a corporate body who sells or agrees to sell goods. Under this section, goods is defined as movable property other than money, and it also includes stock and shares. So an example of goods under this section would be toys, medical equipment, and rubber gloves. Under Section 4 and 5, a contract of sale is defined as where the seller transfers or agrees to transfer the title in the goods to the buyer for a price. So a contract of sale can be absolute or conditional. If a contract of sale is absolute, it is referred to as a sale. So a sale occurs where the title and the goods will transfer from the seller to the buyer at the time of the contract. Whereas the agreement to sell, which is conditional, will only occur where the buyer and seller agrees that the title will transfer at a later date or when a condition is fulfilled after this. So an example of an agreement to sell is cash on delivery. So if you have ordered goods before and you only agreed to pay for the goods when you receive it, which is cash on delivery, that is an agreement to sell. because the title in the goods will only transfer when you fulfill a condition, in this case, which is to give money to the seller. Okay, we will now move on to conditions and warranties. Before we look into defective goods, conditions and warranties are the two important features of a contract of sale. Under Section 12, a condition is defined as the main purpose or a fundamental term of a contract. So a warranty is a stipulation which is collateral to the main purpose of the contract. The differences between a condition and a warranty is the remedy. So a breach of a condition will give the injured party the right to repudiate the contract. So when a contract is repudiated, it means that the contract is cancelled or is abandoned. Therefore, after repudiation, parties will be put back to the position before the contract is entered into. A breach of warranty, whereas, will only give the injured party the right to claim for damages, but not to reject the goods and also treat the contract as repudiated. Under Section 13, as mentioned earlier, an injured party may treat a breach of condition as a breach of warranty. Therefore, if an injured party encounters a breach of condition, they can choose between claiming for damages or cancelling the contract. The case shown here, Tan Chong and Sons Motor, it was held that if the term breach is a condition, the innocent party has the right to terminate the contract and consider himself discharged and claim for damages for the breach. The case also held that if the term broken is only a warranty, the innocent party cannot repudiate the contract and the remedy is only confined to the claim for damages. In the case of a breach of condition, the innocent party can of course treat the matter as a breach of warranty and sue for damages only without having to terminate or repudiate the contract. We will now look into the conditions under SOGA. One of the first conditions is the right to sell under Section 14, subsection A of the SOGA. So under this section, it is an implied condition that the seller has a right to sell. So for example, if a seller sells a stolen car to a buyer, the seller in this case has breached this implied condition because the seller does not have the right to sell the good to the buyer in the first place. So the buyer in this situation may be able to seek damages or to terminate the contract because the seller has breached this condition. In the case shown here, the case of Niblet Limited, the court held that the seller in this case did not have the right to sell the goods to the seller as the goods could be restrained by injunction. The goods in this case was a trademark infringement. Therefore, the seller had no right to sell the goods to the buyer and hence has breached the implied condition. The next condition would be sale by description. Under Section 15, a sale by description is a situation where a buyer has not seen the goods but is relying on the description by the seller alone. Under Section 15, it is an implied condition that the goods supplied must correspond to that description. So for example, if you purchase a Samsung phone online but a Huawei phone is delivered to you, the seller has breached this condition because you have reasonably relied on the description given by the seller and you received a good of a different identity than the one stated in the description. Therefore, the seller in this case has breached this condition. In the case of Arcos shown here, it was held that the correspondence between the description and actuality must be exact. This means that the seller's description must be exact. So for example, in a contract, if the seller's description states that the bags of rice supplied to you is 10 kilograms, the bags of rice supplied must be 10 kilograms. It cannot be less, cannot be more. Therefore, if it's 11 kg, it is also a breach of condition. We will now look into the next condition, sale by sample. Under Section 17, there are three implied conditions. The first one is that the bulk goods correspond to the sample. Buyer must be given the reasonable opportunity to compare it with the sample. And of course, the goods must be free from any defect, which makes the quality unmerchantable, which will not be apparent on reasonable examination. For example, if a buyer orders 1,000 napkins for a function based on a sample given by the seller, the implied conditions stated here will apply. This means that if the buyer receives the 1,000 napkins, the buyer will have the right to compare the bulk 1,000 napkins with the sample sent. And of course, the 1,000 napkins must be of the same quality as the sample that was given. And lastly, they must be free of defects that would not have been discovered when the buyer was examining the sample. The next condition would be fitness for purpose under Section 16, subsection 1A of the SOGA. So in a situation where a buyer tells a seller why they are buying the goods, and the buyer is relying on the seller's skill and judgment, and of course the goods are the kind that the seller's business supplies, it is an implied condition that the goods purchased are reasonably fit for the purpose disclosed. For example, a buyer goes to a seller to buy a bicycle, and the buyer informs the seller that he wants to use the bicycle for mountain trekking. If the seller sells him an ordinary bicycle that is incapable of fulfilling the buyer's purpose, which is for mountain trekking, the seller has breached this condition. It's because the condition of the goods does not fit the purpose that the buyer has informed the seller. Another example would be that a buyer walks into a pharmacy and asks for medication that will cure his sore throat. So in this situation, the buyer is expressly telling the pharmacy or the seller the particular purpose of the goods that he requires. And the buyer is of course reasonably relying on the pharmacist's skill to give him the medication. And the pharmacy is of course in the business of supplying medication. So it is an implied term that the pharmacy will provide and supply the buyer with medication that is good for curing his throat, which means that it is fit for the purpose that the buyer has told the seller. So if the pharmacist gives the buyer medication that doesn't help or cure the sore throat, the pharmacy has breached the condition that the product supplied must be fit for purpose. In the case, another example would be a case of Grant against Australian females. In this case, Grant, who is the plaintiff, bought underwear from the retailer, and unfortunately, he developed severe dermatitis after wearing underwear. It was held in this case that the goods were obviously not reasonably fit for their only purpose, because no one would expect to get dermatitis after using underwear. So in this case, it is clear that there was a breach of implied condition of the fitness for purpose. The next case, Union Alloy, it provides the 4 preconditions that have to be satisfied before Section 16 is applicable. So to satisfy the conditions under this section, there must be 4 points. The requirement, which I've mentioned in my examples earlier, the buyer must have made known to the seller the particular purpose. Second would be there must be reliance on the buyer, on the seller's skill and judgment. And of course, the goods must be in the course of the seller's business to supply. The last requirement here shows that the goods must not be sold under the patent trade name. So what does this mean? So under the last requirement, for example, if a buyer buys a product under a trade name, the seller cannot be held responsible for the usefulness of the quality of the product. Why so? Because the buyer ultimately is not relying on the seller's skill or judgment to supply the particular good. So referencing to the pharmacy example earlier, so if a buyer requires for specific brand, Strepsil, to get relief from sore throat, if the buyer does not get any relief after the pharmacy provides him with Strepsil, the pharmacy cannot be held liable. Why? Because the buyer did not rely on the pharmacies to supply the suitable goods to cure his sore throat. The buyer instead relied on the brand name Strepsil. So in such a situation, there cannot be an implied condition that the Strepsil supply will be fit for the purpose that the buyer intended, because instead of relying on the pharmacy, the buyer actually relied on the brand Strepsil. So in such a situation, the buyer cannot rely on Section 16, subsection 1A. The next condition we'll be looking at is Perchantability. This is under Section 16, subsection 1B of the SOGA. So under this section, it is an implied condition that goods supplied are of merchantable quality. So what is merchantable quality? Under the case shown here, merchantability means the goods supplied must be of a quality and condition that a reasonable person would accept it after examining it. This will mean that the seller has a duty to provide goods that are merchantable and are of course capable of passing the market standards. So in this case shown, David Jones against Willis, the plaintiff purchased a pair of shoes, and after wearing the shoes to walk down the stairs, the heel came off. In such a situation, the shoes are obviously unmerchantable and it wasn't fit for purpose. So an example would be if you buy shoes online and when the shoes arrive and there are holes in the shoes, they are obviously unwearable. So in such a situation, you as a buyer have obviously received a good that is not suitable for the purpose they are bought, and it is also unmerchantable because a reasonable person would not buy such a shoe as it cannot be used. So the next case, Wilson against Ricketts. So unlike fitness for purpose mentioned earlier, under Section 16, Section 1A, under merchantability, if a buyer specifically orders a product with a brand name and the product is unmerchantable, the buyer can still rely on Section 16(1)(b). So the case shown here, the buyer specifically ordered Coal, which is a brand of coal, and the buyer did not rely on the seller's skill and judgment, but the defendant is still liable because the coal here in itself is not merchantable. So we shall move on to the next slide. So under Section 11, whether time is of essence of the contract would depend on the terms of the contract. So in this case shown, Muhammad Said against Ferrari, the plaintiff here sued the defendant, who was a car dealer selling Ferraris. So the plaintiff alleged that the defendant committed a breach because the dealer did not deliver the 2 Ferraris in time. So when this case was brought to court, the High Court held that based on express terms of the agreement and the evidence, time of delivery is of essence of the agreements. So if you go to the next slide, under this section, stipulations as to time of payment are usually not deemed to be essence of the contract unless it is provided by the terms of the contract. So what this means that in essence, under SOGA, whether time is of essence will ultimately depend on the agreement between the parties. So this can be evidence, express terms in the contract, or whether it was verbally agreed, and of course whether it is usually a trade usage. So it is also stated that in commercial or mercantile transactions, which would usually involve time, they're usually treated as being essence of the contract. However, if time is not the essence of the contract, it can be an essence of contract if one party gives notice to the other party, but it has to be subject to 2 requirements. First would be that the other party is guilty of unreasonable delay, and the time mentioned in the notice must be reasonable. We will now move on to warranties. So as mentioned earlier, under warranties, if warranties are breached, it will not give rise to right to terminate a contract, and it will only result in claiming of damages from the party that breached the warranty. Under Section 15, there are 2. One is that the goods must be free from encumbrances. So what does this mean? An example would be where a seller sells a car to a buyer where the government tax is still not paid. Such a situation is where the goods has still an encumbrance. So as a result of this government tax not being paid, the government can seize the car. So if this happens, the seller has obviously breached the warranty. But because it is a warranty and not a condition, the buyer cannot terminate the contract. So what the buyer has to do is to pay the tax and then recover the money from the seller to claim for damages. So under Section 14, there's also the requirement for quiet possession. So what does quiet possession mean? An example would be where X sold his car to Y. However, X still often persuades Y to lend him his car. And aside from that, X, despite selling the car to Y, also still has a set of keys to the car, and he will use the car whenever he likes it. So in such a situation, X has breached the implied warranty under Section 14 because Y does not have quiet possession of the goods because X still access the goods that were sold to Y. So I will now proceed to the next part, and Hannah will continue the talk. Thank you very much.
Thank you, Chu. Hello, everybody. I hope you can hear me clearly. Apologize for the technical difficulties as well as the audio difficulties earlier. I hope you can hear me clearly. I will be taking on the next sections, which are the passing of title, delivery of goods, as well as the remedies available to both the seller as well as the buyer. Okay, what is passing of title? So essentially, it just means the passing of ownership of the goods. And when does the title pass? In a contract for sale of goods, property in them passes from the seller to the buyer according to the intention of the parties. And that intention is to be gathered from the terms of the contract and the conduct of the parties in all circumstances of the case. What this means basically is that parties have to agree on how they want the title or the ownership of the goods to pass from the seller to the buyer. All right. The terms of the contract would be the absolute best, but if there is no such contract or no such terms, then the conduct of the parties, and the court will also look at, how did the contract work and what were the parties conduct during the contract. Sorry, just give me a moment. Okay, next. Okay, so retention of clause, title retention clause, or retention of title clause. so confusing. And Romalpa clause are the common names of retention of goods. The time of the transfer of properties in goods is important to ascertain the liability of the parties. The risk of loss or damage, unless otherwise agreed, passes with the property in them, whether or not delivery has been made. Therefore, the usual case would be that the seller may only sue for the price of the goods if the property in them has passed. So if the title has been passed from the buyer to the seller, or from the seller to the buyer rather, then only you may sue for the price of goods if they don't pay you. In this case, MBF Finance Berhad, payment of a purchase price alone does not pass the property in the goods to the buyer. If there are things remaining to be done by the seller to the good before it is in the state in which it is finally to be delivered to the purchaser, the contract will not be construed to be one to pass the property until those things are done. For example, there is no sale until there is a delivery of the goods to the buyer. To simplify this case, what it means is that if there are a set of things that the seller has to do, right? Just because the buyer has paid the price for the property does not mean that the buyer now owns the goods. Until and unless the seller has done every single thing that is stipulated in the contract, then only. And then if the contractual terms also say that the goods has to be delivered, then only the title of the property will be passed to the buyer. We will now look at the disposal of goods. The seller can reserve the right of disposal of the goods until certain conditions imposed by the seller are fulfilled. Title of the goods will not pass to the buyer until the conditions imposed by the seller are met, regardless of the delivery of the goods to the buyer or carrier. Now, this is the flip side. If parties agree that the seller wants to reserve the right to the title until the buyer has fulfilled condition. This usually sometimes happens in part payments. If you pay me first tranche, doesn't mean that the goods belong to you. So this is just an example. All right. So this is on the flip side, that the title will not pass to the buyer until the conditions imposed by the seller. So it's important that both buyer and seller come in the middle and set out what sort of terms they want with regards to transfer of title. In this case, Pacific Interlink Syndrome Berhad and IP Timbers, plaintiff entered into the contract of sale for purchase of hard redwood timber from the defendant. The condition was that it has to be free from white or yellow species, decay, dead knots, splits, and wane. Who knows timber? Then this is the condition that was imposed in the contract. Now, the goods were inspected by the plaintiff's representative, which is the buyer, and the balance purchase price was paid. So money has been paid already. And then the plaintiff receives a complaint from another purchaser, a third party, that the timber does not meet the specifications required. Before arranging for the delivery, the plaintiff wanted to inspect the timber again to ensure that the goods have met the specifications. The defendant took the ground that the plaintiff has already inspected the goods and that the ownership of the goods have already been transferred to the plaintiff when they paid, and denied the inspection. The court held that the payment of full purchase price does not indicate the transfer of the title of the goods to the plaintiff. The defendant breached the conditions set out in the contract, and that the request of the plaintiff to inspect the goods were reasonable. As such, the plaintiff was entitled to repudiate the contract, which means the cancellation of the contract, and plaintiff had the right to reject delivery of the goods. So this is an important reminder to all of you out there who buy and sell as your job. It's important to have a retention of title clauses in your contracts, which are clear and extensive and covers the rights of both the buyers and the sellers. The contract has given the rights that I have just mentioned earlier, so you can incorporate inside your clauses, and the sellers can prevent the passing of ownership of goods, and buyers can prevent from accepting defective goods. So these are the few benefits of having a clear and extensive retention of title clause in your contracts. Hope that is clear. I will now move on to the delivery. Delivery is fairly straightforward. Section 31 says that the seller has a duty to deliver the goods in accordance with the contract of sale. And then the buyer has a duty to accept and pay for the goods in accordance with the contract of sale. Section 32. Now, if delivery provisions are not agreed by parties or there is no such terms in the contract, the delivery of goods and the payment of price are concurrent conditions. What that means is that it's a simultaneous exchange. Okay? Seller must be ready and willing to give possession of the goods, release the goods to the buyer in exchange for the price. And the buyer must be ready and willing to pay for the price in exchange for the possession of the goods. This is in a situation of a part delivery, and I think this is fairly common where you have different tranches or batches of goods delivered out. Now, a delivery of part of the goods in progress of the delivery of the whole has the same effect for the purposes of passing the property in such goods as a delivery of the whole. However, a delivery of part of the goods with an intention of severing it from the whole does not operate as a delivery of the remainder. What this means is that if you have a shipment of 10 gloves, 10 boxes of gloves, for example, but it's part of maybe just one PO, but it's delivered in batches, that is considered one delivery. Now, however, if you intend to order 10 boxes of gloves, but you have divided them into different orders, so 2 at the beginning and maybe 3 later, and then the rest on a later POs. Now, that can also, that means actually that is you are severing it from the whole delivery. So that is a simple example of the difference between the two. So again, this depends on the contractual terms of the party. How do you want the delivery of goods to be done? As a whole, in batches, and how do you intend to sign your consignment notes? Those are the few things that you have to iron out at the beginning before you even proceed to deliver the goods. This is also something that's happened fairly often. Delivery of wrong quantity. Now, if the seller delivers to the buyer a quantity of goods which are lesser than what he has contracted to sell, the buyer can reject. All right. And if the buyer chooses to accept, however, he shall pay for them at the contractual rate. And if the seller delivers to the buyer a quantity of goods that are larger, that means more, the buyer may accept the goods included in the contract and reject the rest, or he may accept the whole. So you can either choose to accept what you have ordered and then reject the rest, or don't want it entirely. Now, if the buyer accepts the whole of the goods so delivered, he shall pay for them at the contract rate. This is an example for me to show the difference. A ordered 100 metric tons of palm oil from B, and if B delivered 90 metric tons, A may reject delivery of the goods or accept in whole. And however, if B delivered 110 metric tons to A has the right to either reject, accept some, and then return some, and then or accept the entire thing and pay for it. Now, practically, the court will only consider this kind of dispute if the number is significant. If you miss the mark by 1 or 2, court will likely not entertain that claim. You know, if parties can agree amongst themselves, so go for it. But if the item is, the difference is very big, and then the monies that you have, more importantly, the money that the losses that you suffer from the differences, if significant, then the court will look into it and then order accordingly when you ask for damages, for example. All right, so now we go to remedies. Remedies basically is what can be done for the buyer and seller when something goes wrong in their contract, okay? When there is a breach of condition or when there is a breach of warranty. Okay. Section 57 is damage. When the seller wrongfully neglects or refuses to deliver the goods to the buyer, buyer may sue the seller for damages for non-delivery. If there is a market for the goods, the buyer may recover the difference between the price agreed with the seller and the current market price. If the price has increased between the formation of the contract and the breach, damages will be payable. The buyer is also able to recover any losses directly and naturally resulting in the ordinary course of events from the failure to deliver. So if you are a manufacturer, for example, and you rely heavily on the goods that were supposed to come to you, and there is a delay or there is a refusal to deliver these goods to you, and as a result of that, you cannot produce what you're supposed to produce, then you can claim for damages for the losses that you have suffered as a result of that refusal to deliver. In the case of Popular Industries Limited, the court said that the normal measure of damages for non-delivery of goods sold is the difference between market price and the contract price. This rule applies only where there is an available market. That is to say that the buyer should be able to go out and buy equivalent goods out there. So I suppose this is pretty clear. It's important to have a market for the things that you want to claim for, and then you can claim for these damages. Now, if your item is very hard to find, there is nothing else, no other manufacturer who can do it. There is another remedy for you, which I will explain later. Section 59 says that if the seller has breached a condition, but the buyer has by acceptance of the goods lost the right to reject, the breach will be treated as one of warranty. So if you remember what Chiu said earlier, if there is a breach of warranty, your available remedy is only damages, and it's not a cancellation of contract or a repudiation of contract. There is a difference there. The damages will be recoverable for all actionable loss. So the buyer may sue the seller for damages for breach of warranty. And here's a little example of what the court has said about Section 59. Prawn is a prawn. The plaintiff is a prawn breeder and sells his prawns to the defendant, who is the middleman who supplies the prawns to overseas market. The plaintiff claimed for outstanding sum from the defendant, and the non-payment of the sum is due to the low quality of the prawns supplied by the plaintiff. This happens. Defendant counterclaimed for damages caused from the supply of low quality prawns, and the plaintiff applied to have the counterclaim struck off. The courts held that the defendant, because the goods is already low quality, it's not like he can recover, right, the prawns. So he's entitled to damages, and the court held that the defendant's counterclaim was valid under Section 59 of the Sales of Heng. Specific performance. Now, earlier I mentioned that if your item is so novel that only one manufacturer can do it, and there is a refusal to deliver, this is the remedy you can ask. You can ask for the contract to be performed specifically. So under Section 58, the court may, if it thinks fit, on the application of the plaintiff, by its decree direct that the contract shall be performed specifically. This essentially means you are forcing well, not really forcing. It's really asking the parties to follow what you have agreed. There is no other way for me to obtain these goods if you don't do it. So you have to honor your contract, and I'm now enforcing it by way of specific performance. This is the remedy available to you. It is a decree by the court that requires the party against whom it is directed to do what he promised to do under a contract, right? And only in exceptional cases does the court allow this, and its availability is generally subject to the condition that damages will not be an adequate remedy. So if there is damages cannot compensate you for your losses, and you really need that goods and that item, this is a good way for you to enforce your contract. Now we'll go to the seller's remedy. You may sue for the price. Section 55 says that where under a contract of sale, the property and goods has passed to the buyer. So this is when you have already delivered your goods, your DO has already been signed, but the buyer wrongfully neglects or refuses to pay for the goods according to the terms of the contract. You may now sue him for the price of the goods that he has retained title to. Section 56, damages for non-acceptance. This is when the buyer wrongfully neglects or refuses to accept or pay for the goods. The seller may now sue him for damages for non-acceptance. How will the court assess these damages? The court will again look at the difference between the contract price and the market price at the time and place fixed by the contract for the acceptance. Fairly straightforward as well. Seller's remedies. Lien. Lien is having a hold on the property. So unpaid sellers of goods has by implication of law a lien on the goods for the price while he is in possession of them. So if you still have the goods and you are a seller and you still have them in your warehouse, for example, you can exercise lien, which means you can retain possession of them until the full payment has been made. All right, this is another remedy available to you. Stoppage in transit. So the unpaid seller may again exercise his right of stoppage in transit, either by taking actual possession of the goods or by giving notice of his claim to the carrier or other bailey in whose possession the goods are. So the unpaid seller exercised the right by taking physical control of the goods or by notice to the carrier or other custodian of the goods that saying, hey, do not deliver these goods, please stop until I get full payment. Again, these are all according to the contractual terms that parties have agreed. Right of resale. Section 46 says that this right may be exercised if the buyer has failed to pay for goods which are perishable. For example, if you are a seller and you still have not been paid, but your goods are about to go bad, you need to find an opportunity to sell these goods before they go bad. But before you do that, you must notify the owner of your intention to resell if the payment is not made. And if the buyer fails to pay within reasonable time, you now retain the right to resell the goods. And on resale, the new buyer acquires ownership of the goods. And if the seller makes a loss on resale, he or she may sue the buyer for the damages. And the seller can also sue the buyer for the price where the title to the goods has passed to the buyer and the buyer wrongfully neglects or refuses to pay for the goods in accordance with the terms of the contract. All right, that's it, ladies and gentlemen. I have now covered the passing of title, the delivery of goods, as well as the remedies available to both the buyers and the sellers. And I hope that's been clear. But if you have any questions, I will hand the floor over to Rachel, who will moderate the question.
Thank you, Hannah. Thank you, Chu, for your insightful sharing. We will now take questions from the participants from Slido. May I remind all the participants that if you have any questions to ask, you can just scan the QR code and we will get your questions posted up on Slido. Thank you. So for the first question today, how is the situation contemplated under Section 16, Sub 1, Sub A differs from sale by description? Chu, would you like to take this question?
Hi, thank you, Rachel. So the question here asks what is the situation? How is the situation in Section 16(1)(a) differs from sale by description? So under sale by description, the seller actually already describes what the specifications and the conditions of the product or the goods is. But under Section 16, it is the buyer who first informs the seller what the buyer wants, and based on that, the seller would come up with a good that would suit the buyer's needs. So technically, the situation under Section 16, subsection 1A is different because the product, the goods that you want will depend on what the buyer wanted in the first place. So sale by description, the buyer will just choose what is already provided. So if it's a sale by description, the buyer did not rely on the seller's skill and judgment. So that's my answer.
Thank you, Chu, for the answer. I hope the participant who asked this question has got the answer he wanted. For the second question, given that all the basic differences between conditions and warranties as defined in law, why are all clauses in published standard forms of construction contracts typically called conditions of contract instead of terms of contract? Is that just careless, or poor drafting? Hannah, would you like to answer this question?
I can't help but chuckle when I saw this question. Let's just say that when lawyers name, the name can be something different, can be as creative as they want. What the court really looks at when it comes to drafting is the contents, right? So whether the terms that is stipulated there is a condition or a warranty really depends on the interpretation of the court or of the parties, that are concerned in the dispute, for example. So I wouldn't call it careless or poor drafting. It's just how it's named. It's not wrong to name the way that conditions of contract, terms of contract. It's not wrong to name it that way. Even within construction contracts, you see various names for a contract, right? You have the different bodies that has their own standard for contracts, and then you have letters of award, which is also a form of a contract. So, it's not really a matter of the name, it's really the matter of the content, right? So, and the differences between conditions and warranties will come into play more importantly when parties want to enforce their rights. Do I get to repudiate the contract? Do I get to claim for damages? That is most important when it comes to drafting. So focus on that, the content, right? The title can be misleading sometimes. I hope that answers your question. Yeah, back to you, Rachel.
Thank you, Hannah. For our third question, why do advertisements often end in terms and conditions apply? Would it not be more accurate to say terms apply or even conditions and warranties apply? Hannah, would you like to take this question?
I think I can take this question.
Oh, okay, sure.
Okay, so as what Hannah said just now, it is just a way of describing the terms. So actually, in advertisements, is depending on what the advertisement advertises, it's not a contract of sale. Because most of the time, advertisements are what you call an invitation to trade. So even if it puts terms and conditions, it doesn't matter whether it's condition or warranty, unless, for example, the advertisement offers you something. For example, where the advertisement is for a contest, where if you get something, then you can claim the offer. So in that situation, it would be a contract. Most of the time, advertisements are just an invitation to trade. So if you see advertisements showing products like how delicious the food looks or how cheap the discount is, the terms and conditions will apply actually doesn't constitute a contract of sale yet. So technically, it is still a terms and conditions that you have to satisfy. And back to the question, even if it is a conditional advertisement, which would be a conditional offer, it still doesn't matter what it's called. So it will depend on the legal constitution of the thing.
Thank you, Chiu. For our fourth question, does the Act also covers online purchase? Some of the sellers would describe their product will be slightly different from the actual product due to camera lighting and quality of the picture. Thus, this disclaimer releases the seller from their duty under the Act. Hannah, would you like to take this question?
Can I give Chiu this, because then I want to answer the retention of title question.
Okay.
Chiu, can I answer?
Okay, sure. So for this question, I would say it actually depends. Because as I've said previously, it will depend on what is described. So technically, if the seller says that the product will be slightly different, once you get the product and it is really slightly different, then maybe the seller actually is not liable. But if it is like too different or it's unreasonably different, then probably the seller is liable. Because at the end of the day, it really depends. Because if it is a sale by description, because online products are technically under the sale by description section, so it will really depend on what the description is. So at the end of the day, it is back to the principle that buyers beware. Because under the sale of goods in Malaysia, a very important principle is called buyers beware. So the buyers actually have the duty to ensure that they are aware of what they are getting. So if you buy things online and the seller has obviously stated that the product will be slightly different, and you have obviously purchased it and it turns out to be slightly different, the seller can argue that you have been warned of this, and it is up to the buyer yourself to be aware of what was described. So, for example, if you have encountered situations where you have bought something, but you didn't actually go into the descriptions and it turns out to be smaller or bigger than what you've ordered, it's very difficult for you to find the buyer liable because you didn't read the description yourself. So in such a situation, the seller cannot be liable for your, because you didn't do due diligence and you weren't aware of what you were getting yourself into. So to answer this question conclusively, you have to be aware of what you're buying and to read the descriptions of what you're buying online. And if it says it is slightly different, you are actually taking the risk. So if it is slightly different, you'll be very difficult to find the seller. Thank you very much.
Thank you, Chiu. So for the fifth question, which Hannah will be taking, will the right of retention of title be preserved even if the goods, for example, bricks, have been transformed into a wall of a building? Over to you, Hannah.
Okay, the answer here is that what will the form be of what will be the form of the goods after it has been transformed? Now, in your case, wall of a building, it's very hard to ascertain which brick belongs to a certain seller. So now, by that difficulty, you can see that it's really hard for you to be able to obtain your right of retention or title, because it has so mingled with another material or another object that it become a completely different goods altogether. Now, if that's the case, then it will be so difficult for the court to determine how to trace back the ownership, you see. So rule of thumb is that the form has to be identifiable at the end. So if it's completely different, like for example, if it's gas and it's completely dissolved, how do you trace? And if you are unable to trace it, then you wouldn't be able to claim for title on these goods. So my answer is a short no. Yeah.
Thank you, Hannah. For the next question, which one is better to protect online consumers? The Sale of Goods Act or the Consumer Protection Act? Chu, would you like to take this question?
Yes. Okay, so for this question, for online consumers, I would say that actually most of the times, Consumer Protection Act is actually better because the Consumer Protection Act is actually more, I would say it covers more specific situations that day-to-day consumers would face. Because actually Sales of Goods Act is actually quite wide. It doesn't cast a net specific enough to protect day-to-day consumers. So for Consumer Protection Act, under this act, there's actually a tribunal. So if you have any disputes or you have any complaints, you can actually go, before you go to a tribunal, you can actually also report to the NCC, the National Consumer Complaint, I would say, I'm not sure what's the full name, but it's NCC. So actually, Consumer Protection Act is actually better for online consumers.
Thank you, Chu. For our next question.
Actually, if I want to chime in and add, actually it applies, both can apply, but if you want something more specific to a consumer right, then the CPA would be more useful.
For our next question, does the PO falls under the Sale of Goods Act? So for example, the PO was issued in July 2020. However, the supplier informed in December 2020 saying that the raw material has increased and requested for the price increase. What action can we take? Hannah, would you like to take this question?
Yeah, okay. Well, first of all, PO is a form of contract. There is a offer, acceptance, and then there is a consideration stipulated in the PO. Yes, I would say that it falls under SOGA. And then you see here, however, supplier informed that the raw material has increased and requested for the price increase. What action can we take? Well, it's up to you. If you want to, obviously you don't agree to it. Then you can negotiate for you to have the contract terminated if you want to. Otherwise, you will have to come to a compromise on what you can agree when it comes to the price, because this is something that you will have to agree between yourselves. And if it's not something that you can agree, then you have to have some form of negotiation to have it terminated.
Thank you, Hannah. For our next question, if the terms of purchase is using Incoterms, can we still rely on the rights stated under the Sale of Goods Act?
Yep, yes. If Incoterms, sorry, I am just, if you're, as long as the terms that you put in are consistent with SOGA. So the key here is consistency. If they're completely different, then maybe not. But if they come under the Act and they are consistent with the application of the Act, then yes.
Thank you, Hannah. To all participants, we will take 2 to 3 more questions and then we will have to end this session. So for the next question, this question has been asked before, we will skip this one. So for the next question, on section 16 sub 1 sub A, can you explain what is meant by seller's business to supply? Chiu, would you like to take this question?
Yes, okay. So under section 16.1a, there's 4 requirements as I've mentioned. So under the pharmacy example, the first requirement would be that the buyer tells the seller what the buyer wants. And number 2 would be the seller then finds something to suit the seller's needs. And the third one would be the seller's business to supply. So in such a case, it will mean that the seller's business is actually supplying such goods. So in the example I've given, the pharmacy is business. It is the pharmacist's business to supply the goods that the buyer wants.
Thank you, Chiu. So for our final question of today, is the PO to be signed by both parties to ensure that it contractually binds both parties? Hannah, would you like to take the question?
Yeah, okay. First of all, right off the bat, please sign your contracts, everybody. I hope that is clear. Please sign your POs, your DOs, unless there is a dispute. And then you can put a note there that says, I dispute. So, but in the event that parties did not sign, is it contractually, are parties contractually bound? Answer is yes, because despite it not being signed, the action, the conduct of parties are consistent with the PO, for example. So if the POs say, 10 box by tomorrow and you deliver the 10 box by tomorrow, and then the next item is another 10 box by next week, and that is not fulfilled. You know, the fact that parties have partially fulfilled what the PO has mentioned shows that parties has intended to be bound by the terms of the PO. So the court will look at the intention of parties here. So even if parties did not sign, if it's the intention of the parties to have the PO bind their relationship, then yes, it applies.
Thank you, Hannah. Thank you, Ms. Hannah Patrick and Mr. Chiu Jin Heng, for your insights. Before we conclude, I have a few announcements to make. First, please join us again for our upcoming talks. The next one will be on the 24th of March 2021, which is on a Wednesday. And the topic will be on legal agreements in digital technology. This talk will be presented by Ms. Cassandra Tomasios and Mr. Tommy Wong. Secondly, please also fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat box. Thirdly, please follow or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website, or you can scan the QR code on the slide, or you can follow the link which is posted in our chat box. To our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody.
Thank you, everybody, for joining.